In this country, under our Constitution, we have a separation of powers. In California, that issue is a little bit more fuzzy. And the reason for that is that in the 1920s, I think it was 1927, the legislature enacted a provision which I don't think has ever been challenged before, allows the legislature to govern the dues of lawyers to the state bar. Well, as you know, once you govern the purse strings, you in effect can govern the organization. And in 2009, the state legislature enacted a provision that mandates the State Bar of California to review and comment upon its governance. The bottom line was that since there are so few lawyers in the state legislature now, as contrasted with earlier years, where the percentages was much higher, the state legislature somehow takes offense at the state bar because some of the political decisions the state bar has taken over the years. A classic case was when the state bar chastised then Senator Pete Wilson, later to become the governor of the state of California, for his stand on immigration. Or in earlier years where the state bar chastised President Nixon as a result of Watergate. And I frankly don't remember whether they revoked his license to practice law in California or not, but the sting was still there. And of course, President Nixon and Governor, previously Senator Wilson, were in the same political party. So when Governor Wilson had the opportunity, in his last year of office, he vetoed the dues bill for the state bar. That caused panic amongst the lawyers and particularly the state bar of California. For 2 or 3 years, we did not have a dues bill in place, meaning the state bar could not collect dues from lawyers, and they had to find a different way of running the state bar. Well, currently, under the 2009 legislation, the whole idea is for the state bar to analyze how it is governed. And if the undercurrent were to take effect, that is, the undercurrent of this legislation, the state bar would not have any lawyer on its board of governors. It, in effect, would be a consumer agency. It would license lawyers, and it would discipline lawyers, and that's it. The feeling by those who voted in favor of this legislation is that the state bar is there to protect the public, and that's all it's there for. And if it protects the public, then lawyers should not be on its governing body, because lawyers will not vote against themselves, their self-interest. Lawyers will not act in a way that will be solely designed to protect the public. First, I disagree with that premise. Secondly, the fact that the bar exists, in my opinion, exists for 2 reasons. One, obviously, to protect the public. I say obviously. I'm not sure that's really so obvious. I'm not sure but what there should not be a separate agency designed only to protect the public. But set that aside for the moment. Most lawyers believe that one goal of the state bar should be the protection of the public. But the second reason, or the second goal, should be the enhancement of the education and the knowledge of the lawyer, such that they are better able to deal with the issues that clients come to them with. In other words, protect the public. A fact that few people really know is that several studies have shown that 50% of the lawyer population earns less than $100,000 a year. Of that, 50% earns less than $50,000 a year. So you have a very significant population of lawyers that are not really earning a lot of money. It's this population that is tempted to invade the client trust account. So if you really want to protect the public, you'll enhance the profit-making potential of this group of people, 50% of the bar. If you do that, that's a public service. Why? Because they then will not be tempted to invade the client trust account. It seems to me that the whole mentality here is an us versus them mentality, an adversarial mentality. Until such time that the adversarial attitude between the legislature and the state bar can be softened, until we can work together so that lawyers can work for the betterment of lawyers as well as the protection of the public, we will have a serious problem, not only in this state, but also in this country. What most people forget when they talk about lawyers and raise the specter of the first thing we must do is kill all the lawyers, is they forget the second part of that sentence that Shakespeare wrote. He said, and I paraphrase, if we want to control society, the first thing we must do is kill all the lawyers. And so the separation of powers created by our founders had a very profound underpinning. And for the legislature now to challenge the role of the bar in helping lawyers be more effective, in helping lawyers make money, if you will, really denigrates the whole point and purpose of our Constitution. So, as my mother used to say, be careful what you ask for, you just may get it. And if you get what the state legislature is moving toward, you will find a decimation of the state bar and nothing more than a licensing and a disciplinary agency. And all the help that the lawyers get currently from the state bar will evaporate or go to the voluntary bar. So that the lawyers' dues now will go up, not down. The protection of the public will be in questionable hands. And the lawyers will have little or no help in the management of their practice, something they desperately need. Thanks for joining us, and thanks for listening to my rant today.